Welcome back to another video. Today we're talking about your consumer rights. What you can do if you've changed your mind, if you've got a faulty product, it's the wrong size, or it just isn't up to the standard that you expected. Welcome back, I'm Daniel Schensmith, I'm a barrister of England and Wales. When you buy something as a consumer, there are a number of factors that can affect what you can do when something goes wrong. First of all, it depends whether you bought it online or in store, because if you buy it in store, you've got the opportunity to inspect the goods before you pay for them, whereas you don't have that opportunity when you're buying it online. Secondly, it depends why you want to return it. Some people want to return something just because they've changed their mind, some people because it was broken or faulty when you bought it, or thirdly, it just isn't up to the standard that you might expect when paying for the goods. And this is relative to the price that you've paid for the goods as well. For example, when buying a brand new car of a prestige brand for a lot of money, there are higher expectations that this is up to a better standard. There are lots of time limits involved in consumer purchases, so it's easy to get them wrong. But the overarching legislation is the Consumer Rights Act 2015 and the Consumer Contracts Regulations, each of which give you statutory rights as to what you can do and what the trader must do when something goes wrong or you've changed your mind. One of the first things to clear up is that there is no automatic right to return something to a shop just because you don't like it. Whilst it is said that most shops do have a return policy, and that will become part of the contract. And in addition to that, such as in a case that I've won recently against a major luxury brand, if you agree at the time of purchase that you can bring it back just because you don't like it, let's say it was a gift, so long as you can demonstrate that to the court's satisfaction, that will be upheld as a term of the contract. And in that case, I was successful in arguing that it had become a term of the contract, and the retailer should have upheld that term of the contract and allowed them to return it. This differs quite starkly if you bought something online. This kicks in the Consumer Contract Regulations, which gives you a cooling off period of 14 days. This allows you to cancel the contract 14 days from the day that you receive the goods. Or if it's a service contract, 14 days from the day that you enter the contract for the services. The reason that this differs from the 30-day rejection period that you will have heard about is because the Consumer Rights Act implies terms into all consumer contracts, which, if broken, give you the right to reject within the first 30 days on those terms. This is found in section 22 of the Consumer Rights Act and is known as the short-term right to reject. The underlying reason why you have a short-term right to reject is found in section 19. That is because you have the right to enforce the terms that are implied by the Act into the contract. For example, one of the terms implied into consumer contracts is under section 9. That is that goods are to be of satisfactory quality. It is an objective test. That means it's not just what you think, it's what a reasonable person would think. And it's an assessment as to whether the goods are satisfactory given the price, the description, and any other relevant factors. This includes things such as the general fitness for purpose of the product, the appearance and finish of the product, and whether it's free from minor defects such as scratches, and also the safety and the durability of the product. But it's important to note that if your attention is drawn to any of these things before you buy it, then this doesn't apply. Another term implied by the Consumer Rights Act is under section 10, and that is that goods are to be fit for a particular purpose, which is made known to the trader. And this section can be quite far-reaching. If you've told the trader that you want it for a particular purpose, even if it isn't actually fit for that purpose, if they've sold it to you on the basis that it is fit for that purpose and you've made that known, then you can enforce that as a term of the contract. Under section 11, the goods are to be as described, which means if it's a different size, a different colour, etc., then it won't match the description and you can enforce this as a term of the contract. Also, if you've been shown a sample or you've examined some goods before purchasing it and the one that you buy is in a box and you've not actually seen it, it must match the one that you've been shown and examined or the sample that you've been given to which the product should match. So those sections are pulled together by section 19 to give you a right to uphold those as terms of the contract. And if those terms are breached, then you have this short-term right to reject. So that differs from your cooling off period if it's an online purchase, and it is separate to any store policy. I have once been told about a shop that said they don't apply these rules and that their policy overrides it, and that's just not possible. These are statutory rights. If you've gone beyond this 30-day period of the right to reject, there's another time frame that is between 30 days and within the first 6 months. So if in that case you find a fault or a defect or anything that makes it not suitable and things of that nature between 30 days and 6 months, you must give the retailer an opportunity to repair or replace. But it is only one opportunity to repair or replace. It should be done without unreasonable inconvenience to you, and you don't bear the burden of proving that it was there when you bought it. If it is found within the first 6 months, it is taken to have been there at the time of purchase. Once the first 6 months have passed, the burden shifts onto you to prove that the product was faulty or had a defect at the time of purchase. The usual way you would prove this is by having some kind of written evidence or notes or an email to the shop to say I found something wrong with it. But if you didn't exercise your short-term right to reject in the first 30 days or even in the first 6 months, you may be questioned as to why you left it later, but it would stand up as some evidence that you found it early on and that it was already there. Now, of course, most large shops will have their return policies and are generally not too difficult when you are returning something, particularly if it is within a relatively short period of time. It's also worth bearing in mind, although there are various rules involved, that if you purchase something on a credit card or a point of sale loan or finance agreement, there are additional protections which I'm going to go into in another video. As always, there are some exceptions to these rules. Things such as DVDs, music, software, returns may be denied if you've broken the seal. That's because the underlying principle behind purchasing those is that you are paying for a license and not the product itself. You also won't normally be able to return things that have been deliberately customized, but there are varying degrees on this. For example, if it's just curtains that have been cut to a specific length, you may be more likely to return those. An obvious example is that if you've had your name engraved on something, then you won't be able to return it. There is also a lot of discussion over whether you need the original receipt in order to return a faulty product. The key there is if it is faulty and you're returning it for one of those reasons, not simply because you've changed your mind. If it's the latter, then the retailer most likely will insist that you've got the original receipt. But if the product is faulty or not fit for purpose or any of the above described and you're within those time limits, any proof of purchase is sufficient and you do not need the original receipt. And finally, one other area that comes up a lot is whether or not you can be forced to have a credit note. This similarly only applies if it's just an unwanted item and you're returning it at the goodwill of the store under their normal returns policy and not that it is faulty. If it is faulty, broken or defective, not fit for purpose, they cannot force you to have a credit note. As always, there are lots more rules and regulations that I haven't covered in this video, and there must be 1,000 more questions, so please drop questions in the comments box below and look out for my channel memberships where I'll be diving much deeper into the law. Thanks for watching.